Greetings, students. Hi, this is Satyaki Chakraborty from Indraprastha Law College, Greater Noida, and today's topic of the day is the Privy Council, and the subject is legal and constitutional history. So let us first see let us first understand the basic introduction to the topic of Privy Council. So, what is Privy Council all about? Privy Council is an advisory body. Under the concept of the sovereign as the fountain of justice, the subject could petition to the king in England, who dispensed justice with the assistance of the council. This is called the King in Council. Since it is an advisory body, it is the highest court of appeal. When it heard appeals from the courts of overseas territory like India, it was called the Privy Council. तो प्राइवी काउंसिल एक एडवाइजरी बॉडी होता था जो सॉवरेन स्टेट के अंडर इंग्लैंड में एग्जिस्ट करता था. तो ओवरसीज जब हाईएस्ट कोई अपील जाता था टू द हाईएस्ट कोर्ट ऑफ अपील, इट वाज डायरेक्टेड टू द प्राइवी काउंसिल. सो जो ओवरसीज अपील इंडिया से इंग्लैंड के पास जाता था एंड इट वाज कंसिडर्ड टू बी द हाईएस्ट कोर्ट ऑफ अपील, it was directed towards the advisory body, which is the Privy Council itself. The work of this is commendable, and in establishing the highest judicial standards, it is unique in the Indian legal history. Appeals from India to the Privy Council were abolished in 1949 when the Supreme Court of India was established. तो ये 1949 चला कि कभी कोई एक्सट्रीम डिसीजन के लिए या फिर कोई अपील किया जाता था, and the last court at the highest court of appeal was Privy Council that existed in India. In England itself. And this appeal was made from India to England itself till 1949. And this was abolished with the establishment of Supreme Court in India. Now let us look at the merits and the function of the Privy Council. Pursuant to the Indian High Courts Act 1861, the three courts were established in the place of Supreme Courts. Of course, we discussed about the High Courts in the last class, the three High Courts that were established in Calcutta, Bombay and Madras. But appeals were allowed to the Privy Council if the value of the suit was rupees 10,007 and above. Special leave appeals were also allowed. In 1935, the Government of India Act provided for a federal court, but the above appeals from the various high courts to the Privy Council were left untouched. In addition, appeals were allowed from federal court to the Privy Council. So, 1935, government in India provided for a federal court, but above appeals from various high courts to the Privy Councils were left untouched. So, all of those appeals from the high courts to the Privy Councils were left untouched. And finally, in addition to the appeals were allowed from federal court to the Privy Council itself. The Privy Council by 1833 had its record about 300 appeals. There were also a good number of appeals from Sarad Diwani Adalat. So by 1833 on its record, there were 300 appeals, and a good number of appeals were also made from Sadar Diwani Adalat. Many reforms were introduced time and again. By the Act of 1833, the composition of the Privy Council was also changed. And when we talk about the Act of 1833, here we are talking about the codification and the commission of law itself, which we'll discuss in the next class. By just know the gist that when we talk about codification of law, we are talking about law being written down. All this law that we are studying right now, be it the Civil Procedure Code, Criminal Procedure Code, taxation, successive acts, all of this started from 1833 onwards, and this we will discuss in details in the next classes, which comes under the purview of codification and commission. So many reforms were introduced time and again with the addition of 1833, and the composition of Privy Council was also changed. More lawyers and judges were allowed, and it was kept on par with the House of Lords. From 1915 to 1949, there was a separate branch of Private Council to hear appeals from India itself. Appeals to the Privy Council were abolished from October 10, 1949 by the Constituent Assembly, which made the Abolition of Privy Council Jurisdiction Act. Pending cases were transferred to the Federal Court, and the Federal Court continued up to 26/1/1950 and was abolished when the Supreme Court was established. So this was a basic gist of a function and history or the background of Privy Council itself. So, of course, Privy Council played a very important role in handling the highest position as an advisory board as a decision maker when the appeals overseas were, you know, transferred from India to England, and it continued to operate till 1949, till at that very point in time when Supreme Court was established in India itself, it was abolished. But it played a very pivotal role in all this era, where it functioned as the highest court of appeal in England itself. Now let us look at the advantages of the Privy Council. As a judicial institution, Privy Council was a very unique and almost without a parallel in history. So it was very unique in its form, and it was unparalleled in history, in the legal history of India and England. The range of its territorial and the jurisdiction from the British Empire covered nearly 1/5 of the human race. The judges were preeminently very qualified and had a professional, eminent and legal learning to meet the onerous duties on the bench. They had rare insights in the legal domains of law and also in the appreciation of personal laws like Hindu and Muslim laws, and their mastery of law could be reasons for its success. Its association of India for about 175 years gave India law a proper uniformity and definiteness. The common law in England could extend its benefit to overseas territories. The Government of India paid tributes to the Privy Council on 6th February 1950. It commended the valuable services rendered by it and the highest sense of detachment, independence and impartiality it displayed. It was a unifying force in the judicial realm of India. So, if we draw a conclusion of Privy Council, what we tend to see is Privy Council was an administrative advisory body and was the highest form of advisory body, where highest form of appeals from India were transferred to England for its decision, and this gave the Indian law a proper definiteness and uniformity, and it served the legal body for 175 years till date 1950 or 49, 50 भी आप कह सकते हो, क्योंकि 1950 26th जब 26th of January 1950 को जब सुप्रीम कोर्ट एस्टैब्लिश होता है, प्राइवी काउंसिल गेट्स abolished. So the common law in England could also extend its benefits with its overseas territories with the introduction of Privy Council. And Privy Council comprises of very qualified lawyers and jurymen who are very much knowledgeable in the fields of law and also in the domains of personal laws like Hindus and Muslim laws, and they could provide proper judicial assistance and render proper effective services in handling the appeals too. So Privy Council has served the British judicial system in the domains of legal history for 175 years, and various changes were made, and thus it plays a very important role since its introduction for 175 years, and various changes are also introduced in the existence of private council with 1833 codification and commission, later in 1861 when the high courts were formed and the other forms of court were abolished. So this is how private council plays a very important and a significant role in the domains of Indian legal history. Thank you.